Hi everyone, my name is Rabita, and today I'm going to do a quick review of a journal by Milgosia Fitzmaurice with the title of Concept of a Treaty and Decisions of International Courts and Tribunals. In the past few weeks in class, we've been trying to define what a treaty is under the 1969 VCLT. Instead of using a linguistic or theoretical approach to define a treaty, the writer managed to come up with new elements on how a document is considered a treaty by looking at international tribunals' decisions. Of course, the journal was written with Article 1A of the 1969 VCLT as a starting point. Here we can find a clear formal definition of a treaty, which is defined as an international agreement concluded between states in written form and governed by international law, whether embodied in a single or in two or more related instrument, and whatever its particular designation. Apparently, this clear formal definition of a treaty has proved to give rise to controversy, given the conflicting views and the lack of common understanding between states. The first thesis given by the writer was derived from the opinion of Judge Jessup, and yes, this is the same Jessup used to name the biggest moot court competition in the world. In the case of Southwest Africa, Judge Jessup established, and I quote, "The notion that there exists a clear and ordinary meaning of a treaty is a mirage, and that a treaty is distinguished from other instruments if a state has given a promise or an undertaking from which flow international legal rights and duties." So apparently, the main thesis is that a treaty must be legally binding and creates legally binding rights and obligations. This thesis was confirmed in the case of United Kingdom versus Iran, when the ICJ faced a question on whether a contract signed between the Anglo-Persian Oil Company, owned by the British government, and the Iranian government constitute as a treaty. The court then concluded that the agreement does not contain any legally binding rights and obligations between the two governments. Hence, it is a mere concessionary contract and not a treaty. Subsequently, the writer came up with two important elements used by international tribunals to answer the question of whether a treaty is a treaty. Tribunals tend to look at, first, the form of a treaty, and second, the substance of a treaty. When it comes to the form of treaty, apparently the writer was referring to the term used to call the document. The VCLT does not prefer or specify a particular written form for an international agreement to constitute as a treaty. It can either be a charter, a joint communique, a convention, or even a verbal declaration made by this guy, the Foreign Minister of Norway. Then we face this question. Is form decisive towards the existence of legally binding rights and obligations? The answer is no. The form of a treaty is not determinative. As can be seen in the arbitration award of Philippines versus China, the tribunal was assessing on whether the China-ASEAN Declaration constitute as a treaty. Apparently, the declaration is somewhat not a treaty because it does not contain any new legally binding obligation, but it merely reaffirms the existing rights and obligations. Hence, the tribunal concluded, and I quote, "It is not a legally binding document, but rather an aspirational political document." The case of Greece versus Turkey was also in the opinion that the form of a document is not decisive, but instead, what is decisive is the circumstances surrounding the conclusion of the document. Lastly, in Qatar versus Bahrain, the ICJ decided that exchange letters and minutes were indeed legally binding international agreement, because it does not simply contain the record of a meeting, but it contains the commitments which parties have consented to. So here we can actually see that a thing that is called a declaration is not a treaty, but minutes and exchange letter can indeed become a treaty. Therefore, form is definitely not determinative. And based on these case laws, it is implied that, ta-da, substance is of a particular importance. Tribunals often take the same approach by looking at the substance of a document. In contrary to the minutes in Qatar and Bahrain, which constitute as an international agreement, Minutes, in the case of Bangladesh versus Myanmar, was concluded not as an international agreement because it merely contains the understanding of both parties of the negotiation process. Same document title, different substance, different conclusion of whether it's a treaty or not. And that, everyone, is the summary of the journal. What do I think of it? Is it right, wrong, good, or bad? First, I think the article did an excellent job trying to collect new elements that can serve as a complementary threshold to Article 1A of the VCLT. I completely agree with the writer who came up with the conclusion that substance matters more than form. However, the writer gave a hint of many more elements that she did not further elaborate clearly. For example, the intention of the parties, the situation surrounding the conclusion of the document, or even the subsequent practice after the conclusion of the agreement, which I find very much relevant to the determination of whether there exist rights and obligations or not. Secondly, the entire journal heavily relied on the finding of whether there exist international rights and obligations that are clearly legally binding, derived from Judge Jessup's opinion. However, is this really the golden threshold to determine a treaty? I think not. Merely relying on the existence of a legally binding rights and obligations would exclude international agreements that nonetheless owns the character of a treaty. For example, environmental treaties, which mostly does not contain a binding rights and obligation. Lastly, using form and substance to determine a treaty would not be complete. If we look back at the definition of a treaty, the phrase international agreement refers to the form, and the phrase governed by international law somewhat refers to the substance. But the writer seems to completely left out the last phrase of the definition, which is whether embodied in a single instrument or in two or more related instruments and whatever its particular designation. Overall, I think the article gives enlightenment towards the complexity of determining the character of a treaty. It is safe to say that even court decisions are still inconsistent, but we are definitely starting to see a pattern that is widely used by international tribunals to define a treaty. Thank you so much, guys, for watching, and stay safe, everyone. Bye!